This is the Landlord Advocacy, where we help landlords become better landlords. I'm your host, Matthew Lyman. We have, over the last few months, been reviewing newsprint and social media ads from landlords who are looking for tenants. They have certain stipulations that they have in those ads that they're looking for. Well, some of those stipulations are illegal. Illegal. That will cost you thousands of dollars if you apply these stipulations to looking for tenants. Now, these stipulations and these violations are regarding New York State. But for you landlords who are watching, please understand that although this is in New York State now, and maybe in some other states, this could become a law tomorrow or next month in your state. So take this as a call to action and say, this is happening in New York, we cannot have it happening in our state. And what this law is now that is harming landlords is this. On April 12, 2019, the New York State Human Rights Law has been changed, Article 296, Subdivision 5. And what that has looked at is it looks at protected classes of citizens when it comes to housing, some of which we all know is family status, marital status, race, creed, color, age, sex, sexual orientation, and quite frankly, they should be protected. They should be. You should not discriminate based on any of those factors when you're looking for a tenant. But what this law did on April 12th is it added another class of protected citizens. More of a mechanism that landlords look at, or more that tenants look at when they pay their rent. And what this new protected class is this. What they call lawful source of income. Lawful source of income. Now you might say to yourself, well, Matt, what does that matter? They go to work, they get a paycheck, they pay their rent. That's what we're looking for. So what's the big deal? Wait a minute. That's not what they're looking at as lawful source of income. What they're looking at is different sources of revenue that tenants get to pay rent. And some of those are the following. Child support. You can no longer say, no, I do not accept those tenants who receive child support. Now, the reason why that is, why landlords have done that, is that child support, the non-custodial parent might say, I'm not paying anymore. Now there goes a source of revenue to pay the rent. The other one is alimony and spousal support, maintenance payments from one spouse to another. That might end as well. So landlords don't want to consider that as a source of revenue to pay rent. Another one is foster care subsidies. Great that people want to foster children, it's fantastic. But maybe they might say, you know, I just can't do it. I just don't have the ability anymore. I don't want to do it anymore. And there goes that source of revenue to pay the rent. That's gone bye-bye. So another step where landlords may not get that money that tenants may owe to them, because now that subsidy ends. There are three other ones that are considered lawful source of income that should infuriate you when I tell you what they are. Local, state, and federal housing assistance, such as Section 8, Shelter Plus Care, which are direct federal and state payments for housing and housing alone. Another one is local, state, and federal public assistance, what you may commonly know as the Department of Social Services, also known as welfare. Another one is any other form of lawful income. Now, all of you are saying is that, well, you should be. And as controversial as this may sound, how is any of that considered lawful source of income? We know income is that which we get from working a certain amount of hours every week from an employer giving us a check. Or if you're self-employed, money that you pay yourself for working very hard to help your customers and clients. That's lawful source of income. The government says no. Welfare, DSS, Section 8 is a lawful source of income that you can no longer say no to. I can recall we had a case last year in court where the tenant owed $650 a month in rent for 3 months. An agency that is funded by the government, but is a private agency, but receives public funds, said to this tenant, if you pay the $650 that you owe, we will pay the additional $1,300. This tenant, in fact, paid $650. The agency cut a check to our client for $1,300, so that one individual received a subsidy of $1,300 to pay his rent. This individual, we know for a fact, middle-aged man in his 30s, we knew that he was working, generating revenue for himself, but still was able to receive those funds to pay his rent. Subsequently, about 2 months later, he was evicted for not paying his rent. So now, landlords can no longer say no to Section 8 or DSS, welfare, any form of income. Now you can ask, where do you get your revenue from? Where do you get your income from to pay the rent? Where does that come from? And you can analyze that. And you want to make sure that it's enough to pay the rent that you asked for. Most landlords and property managers and real estate agents look at 3 times the income of what the rent may be. So if it's $800 a month, the tenant must make $2,400 a month in income. They analyze that. But now you can't deduct any of those other sources of lawful source of income when you consider placing that tenant looking solely at their income. There is a possible way around this, and that is credit score. That's the one thing that is still safe in the state of New York to analyze. Now, again, this might seem controversial with what I'm going to say, and if it is, please let us know. Let us know what you think in the comments below. Don't forget to subscribe to our channel, hit the like button, hit the thumbs up. That lets YouTube know that you and everyone else likes the video and you want to see more of it. Now, what may seem controversial, what I'm going to say, is that how many of those that are on these programs, especially public and housing assistance, will have a credit score of 675 or 700 higher in order to place that tenant? Now, I'm coming from a background where in my late teens I was homeless and I was on my own. I resided in the woods. I received public assistance to finish high school. I received some Medicaid assistance to help me through college. And for a moment, I want to say thank you, taxpayer, for helping me to get where I am today. Thank you. I appreciate that. I really do. But how many of those who are receiving assistance have that gratitude? How many of them have that? How many of them have gone from a credit score where mine was way in the dumps and worked very hard to get where I am now, where my credit score can't not get any farther north than what it already is? Now, we're not saying on this channel that those on public assistance and housing assistance are bad individuals. We're not saying that at all. I was not, and there's a lot of people that are not bad citizens who are on these programs. They really are not. Some of them are great. But you should have the option as a landlord property owner to say, no, I do not want these programs. That should be allowed. But here in New York State, it is not. You cannot say no to welfare or DSS. Now, there are options that you are allowed to do this. If you have a boarding home in which you live in that boarding home when you rent rooms out, you can say no. If you are renting out a boarding home where everyone living in that boarding home is of the same sex, you can say no. Now, here's the one that is most important to most of you who own a a two-family home where you reside in one of those residences. You can say no. Anyone in a two-family home where you reside in that home, you, not your brother, not your sister, the actual person on the deed, can live there. And the other apartment, you can say no to DSS, Section 8, any of these programs. I do not accept them. I'm surprised that New York State Division of Human Rights would allow that to go through. Who knows if they're going to amend it again, as they did on April 12th, to include these sources of income, lawful sources of income, and they're going to change it now to where you cannot say no across the board to anyone on any of these programs. We asked, how fair is this? This is your property. How can the government tell you this? And in an upcoming video, we're going to talk as well about landlords who choose not to accept these programs. Most of them did not, and that's why this law was enacted when the amendment took place is since landlords in court were saying, I do not want these programs, I do not want them. And what was happening is that they could say no. And it became important, it became an issue because now tenants had no place to go because landlords were saying no more. I don't want these programs. And that's why the law was amended. So now in court, you have a tenant that you're evicting for non-payment of rent. And the tenant says to an agency, I'm going for DSS help, Department of Social Services assistance. Now the court must say to the landlord, you have to accept this. You have no say. Now that case can be adjourned for 2 to 3 weeks or more to see whether or not the tenant qualifies. And the determination period can be anywhere between 30 to 45 days. So it could be extended that long when you want to get this tenant out. You find out 30 to 45 days later that this tenant does not qualify for these programs. Now you've had more money not paid to you, and now the tenant stays longer, and you have to get the tenant out. No revenue coming in. Again, that is why landlords said, no, I don't want these programs. And the government said, well, now you must take them. The other thing that the governments are looking at, and it has been passed in some areas, is that if you leave your apartments empty, because you want to, but you pay the taxes on those properties, you pay for the upkeep, you pay for all of that. Some governments are enacting laws where if you do that, you have to pay a fee every month to the government for your vacancy in your apartments. Why should that happen? It is your choice. It is your choice to say, I don't want to rent out my apartment, but yet I'm paying the taxes, I'm keeping the apartments up, it is my choice. And some of them are even going so far as to call it low-income housing. So not only are they mandating that you have to place tenants, but they're claiming that we're going to put in low-income housing. Now we're going to talk more about that in a future video. We're going to analyze those governments that have enacted these laws or ones that are looking to do so. Again, something else landlords need to take a call of action to handle. Because our friends, as we have told you before, we need to address all of these issues that are happening to landlords. Because it may not be affecting you today, but it could affect you tomorrow. We need to address this. We need to come together as a large coalition. The tenants have large coalitions. They have a large local and state and federal voice through advocates and advocacy and themselves. Landlords, we need to do the same thing. We need you to join. We need you to subscribe to this channel. We need you to share this video and all the other videos that we have on all platforms, social media platforms. Send them to your friends. Send them to your fellow landlords. Subscribe to our channel. Like our video. Hit the notification bell so you will hear and see other videos that we are producing. And remember this, landlords, as we have said to you many times before, we are here with you. We are here for you. And we want to win. We need to get help for ourselves. Landlords, take care.